Good evening, ladies and gentlemen. I'd like to welcome you to the September 13th special meeting of the Morris Township Committee. Legal notice required in accordance with Public Open Meetings Act has been satisfied, and the state is certifying the same will be executed. And do the pledge of allegiance now? Not a roll call first.
Mr. Arvides is absent. Mrs. Wilson? Here. Mr. Sisler is absent. Mr. Nunn?
Here.
And Mary?
Yeah. Join me in the pledge of allegiance, please. Mr. O'Reilly. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Mills.
Yes, Mayor. Resolve this body recess to closed session. Don't worry, it won't be not more than 15 minutes to discuss personnel and legal matters. Further resolve that the public be made aware of the nature of those discussions at the appropriate time.
Somebody move the resolution, please.
So moved.
Second.
Second.
All in favor? Aye.
It'll be going fair.
Okay. Won't be more than 5 to 10 minutes. Consider at 6:15. We will read.
Oh, wait, we need Ruby. Oh, he's
I'm
right
sorry.
there.
See.
He's so far.
Call the meeting back to order, please, and Mr. Mill, ordinances, public hearing, and final consideration.
Yes, Mayor. Ordinance 24-18 by title, amending Chapter 57, Article 1, Section 3, entitled Word Usage Definitions, and Chapter 95, Article 2, Section 5, /entitled Designation of Zones, and amending Chapter 95, Article 2, Section 6, Zoning Map for Township of Morris to include TH6/AH and Article 3, Section 20.2, entitled TH6/AH, Townhouse Residential Affordable Housing Zone, the Code of the Township of Morris, for public hearing and final consideration.
Before we get started with the public portion, Mr. Phillips, could you just give us sort of a resume or a summation of what your findings are and where we are?
Sure.
Mr. Phillips is the township planner, for anyone who's not aware of that.
So what I thought I would do was, for both the township committee's benefit as well as the public benefit, is just give sort of a brief framework as to how we got where we are this evening in terms of the ordinance. I know some of you know that, but not everyone probably knows all the details. I think it would be a good idea to just go through that. So at what was scheduled to be our final compliance hearing before Judge Neergaard, the Sisters of St. Elizabeth objected to the inclusionary zoning, the TH8 affordable housing zoning that was adopted by the Township Committee for their particular site. The primary basis for their objection was that the development standards they felt were too restrictive, and they could not realistically produce or yield the 220 total units that were permitted, together with the 33 affordable units, which was based on a 15% set aside, 15% of 220 being 33. They also appeared and objected strenuously to the minimum separation requirements that were in that ordinance, which separated both any affordable, any building which had affordable units to the common Liberty Greens boundary line. They also objected to the separation requirements to having any community or recreational facilities being a certain mandated distance from that common Liberty Greens boundary line. I will also say that the Fair Share Housing Center similarly objected to these requirements, and suffice it to say that the court-appointed special master also offered what I will describe as little sympathy for same in terms of those requirements. So the judge essentially sent both parties back to the drawing board And the judge indicated if common ground could not be reached, she was prepared, as she said way back at the end of last year, that she was prepared to go to trial on this. And again, I need to emphasize that if we were to have to go to trial, all bets in terms of our settled number, our plan, and what you have before you this evening in terms of zoning for the Sisters of Charity site would in effect be off the table. She also intimated, I'll use the word intimated, and she did this at the last time we had a hearing before her, that she would take away our immunity, which would render us vulnerable to builder's remedy lawsuits. And I will also just say that Jim and I sit on the TCC. We've had a lot of recent proposals that have come before us and are about to come before us that included a fairly significant multifamily component. So that's just out there. So having said all that, what I'd like to emphasize is that the zoning that you're considering this evening, the new zoning, which was basically negotiated by the township staff and professionals, I believe is quite favorable to both the township and to Liberty Greens. And I'm just going to kind of go through that briefly and highlight that. First, notwithstanding the sisters' objections to the, on principle, to the separation requirements, this zoning maintains the 500-foot separation requirement between Liberty Green's zone boundary line and any multifamily affordable building. It's still in there at 500 feet. Second, and notwithstanding the same objections, this zoning maintains the 350-foot separation requirement to any recreational or community facility, again, from the Liberty Greens common boundary line. Third, the total project density has been reduced from 8 units per acre to 6 units per acre, meaning that there are now a maximum of 165 total units, market rate and affordable, as opposed to the 220 units that were the maximum yield under the TH8 AH zoning. Fourth, notwithstanding the reduced density, the sisters site must still now provide 33 affordable units. An effective 20% set aside. They've increased the set aside from 15 to 20% while reducing the overall yield. And again, I will remind the committee and the public that the minimum presumptive density for affordable rental housing in terms of the set aside is 15% based on the code rules that have not been validated, which is essentially the second round rules. Fifth, despite the site challenges, and the site challenges I think we're all at least to some extent aware of in terms of wetlands and topography, and by topography I mean steeply sloped areas, and the need to allow for additional market rate product other than townhouses, I will say that this zoning does not allow any market rate multifamily affordable buildings. The only multifamily buildings are affordable. What it does do is allow, in certain circumstances, for stacked townhouses. Stacked townhouses being basically something that looks like a townhouse, but there's one unit above another unit. We have some controls in here to control the mass and scope of those stacked townhouses. We also have a standard in the ordinance that doesn't permit any stacked townhouses within 400 feet of the common lot line with Liberty Green, so that there's a smooth transition of townhouses at Liberty Green for another 400 feet, townhouses before you transition to stacked townhouses, and then at 500 feet you can transition to the multifamily affordable buildings. The other thing is we did change the height definition to account for development in the interior of the site where there are some steep slopes, but we did put in a provision so that any conventional townhouse that's within 100 feet of the Liberty Greens boundary, that any facade or face of that townhouse that faces Liberty Greens basically has to be no more than 35 feet in height for that face. So again, we're trying to basically have the smoothest transition to the townhouses that exist at Liberty Green. We also continue to maintain the minimum 25-foot landscape buffer, again, along that common property line. So again, that kind of summarizes where we came from, where we are in terms of the ordinance this evening. And I think all things considered and under the circumstances, I think this ordinance serves the township well. And I would also say that it affords the necessary protections to the residents of Liberty Greens.
Mr. Mills, anything else from you, sir?
Yes, I would like, with your permission, to read into the record a letter from the attorney for the sisters, Mr. Eisdorfer. It's not terribly lengthy. It's captioned regarding proposed ordinance 24-18, the one that is before us, obviously, this evening. Addressed to Mayor Mancuso. Dear Mayor Mancuso, I am writing on behalf of the Sisters of Charity of St. Elizabeth to comment on the proposed ordinance 24-18, which is scheduled for public hearing before the Township Committee on September 13, 2018. Please accept this letter as evidence in that hearing in lieu of live testimony. Among other things, this proposed ordinance would rezone property owned by the sisters for inclusionary multifamily residential development in furtherance of the housing plan approved by the Law Division of the Superior Court to address the township's constitutional fair share housing obligation. This proposed ordinance has been crafted by the township's professionals with considerable input by the sisters. The sisters is grateful for the consideration shown to it in this process. I write to clarify one technical provision of the proposed ordinance. Section 95-20.2D2 authorizes subdivision of the property. That section provides, quote, if the development is internally subdivided, no additional bulk requirements shall be applied beyond those set forth herein, end quote. Based upon communications with the township professionals concerning the meaning of this provision, the sisters understand that if the property is internally subdivided, there will be no required setbacks or buffers from the new property line created by the subdivision. That's all internal to the subdivision, obviously, or to the project. Continuing, with this understanding, Sisters fully supports this proposed ordinance as noticed and respectfully urges the Township Committee to adopt it. I thank you for your time and attention in this matter. I further received an email from Mr. Eisdorfer with respect to certain proposed amendments that are going to be on the floor this evening through Mr. Simon, the attorney for Liberty Green. And just to sum up Mr. Eisdorfer's letter, he states that that's not the letter. What he concluded was that he felt that if any modifications were, I apologize for not having that email in front of me, he concluded that if any modifications were made to the proposed ordinance, in his opinion, it would deprive his client of a realistic development opportunity, which in the arcane language of affordable housing is a death knell. So that is where we are.
All right, well, if we're ready, we'll open the meeting to the public. I'd like you to have between 3 and 5 minutes. And if it's a reiteration of things we've heard before, please address your questions to Mr. Phillips and or Mr. Mills. And yes, your first.
Rob Simon from Herald Law on behalf of Liberty Greens Association. A couple of just preliminary things. First of all, I object to Mr. Eisdorfer submitting a letter without any live testimony being available for any type of cross-examination regarding comments as to this proposed ordinance. I further object to communications that apparently took place without my knowledge this afternoon between counsel Mr. Mills and Mr. Eisdorfer regarding proposed changes that I, as a professional courtesy, provided to Mr. Mills and other members on the dais. So the fact that there were communications back and forth without my knowledge, without my input, and the fact that Mr. Eisdorfer, apparently via email, unilaterally determines, without any type of evidence, backup, live testimony, or otherwise, that any change that we may propose tonight, which we haven't even gotten to by virtue of a public comment, deprives this client of a realistic development opportunity is ridiculous. And it is contrary to municipal land use law, it is contrary to New Jersey statutes regarding the introduction and adoption of ordinances and public hearings.
Thank you.
Thank you, sir.
With regard to the comments, I completely disagree with the fact that any change at all, as determined by Mr. Eisdorfer, deprives his client of a realistic development opportunity with regard to the subject site. We originally participated in negotiations on an original ordinance that ultimately Mr. Eisdorfer's client objected to at the time of the fair share compliance hearing, apparently. Then there were, I guess, discussions between the township and Mr. Eisdorfer and his client regarding changes to an ordinance, all without the input of Liberty Greens, after Liberty Greens went out of their way to not only negotiate, but also concede on many points that were of concern to Liberty Greens in consideration, and I was here last time, of trying to come up with an acceptable plan that would be workable for Liberty Greens, workable for the sisters, and workable for this community, including the Township Committee. To find out on the 11th hour that there were changes made right before the ordinance was originally introduced, and not giving us an opportunity to meaningfully participate, notwithstanding the good faith efforts of the Township Committee up to that point in allowing us to participate, to not being allowed to meaningfully participate in essence, tweaking the ordinance to make it better for this community is not right for Liberty Green, and it's not right for the citizens of the township. As you know, and I've stated it before without repeating myself, Mayor, and I apologize for this, that there are restrictions for the Liberty Green site that are much greater than the restrictions that are ultimately set forth in this ordinance. And some of them we conceded in the betterment of getting a plan that is workable, that satisfies your affordable housing requirement. However, there are other requirements in this ordinance that are vague, unclear, unfair, or that will open up the development at the time it gets presented to the planning board of changes that will adversely and would adversely affect the residents of Liberty Green. I have, apparently Mr. Eisdorfer, unbeknownst to me until this moment, has also seen this, but I have submitted, can I approach?
Sure.
Sorry.
What time was this submitted?
This was submitted today after we had a conference call right before the ordinance was originally introduced. I had a conference call with professionals, attorneys, and we went over these changes. And they said, okay, we'll get back to you. Nobody got back to me, Mr. Nunn, no one. Until I was told that there was a hearing scheduled, okay? And as a courtesy, I contacted Mr. Mills this morning, told him I was going to be there. He asked me what the issues were. I said, I have issues, and he said, what are they? I said, well, let me see if I can communicate them with my client. I can reach out to my client. He said that would be fine, and I communicated them. Okay? So, if you can pass, I'm sorry, if you can pass these along, please. I know you've all seen them, or I suppose you've all seen them, because as a courtesy, I provided them. I marked this L1. I need to, for purposes of the record, go through these. And again, I'm going to go back to Mr. Eisdorfer's language from his email that I have not yet seen, which is preventing us from engaging in a realistic development opportunity. Let's go through them. Starting on page 2, subsection B4 of 95-20.02. I am proposing changes to clarify that these recreation paths are natural and they are not to be used for motorized bikes such as ATVs. I've been involved in cases where there has been approval for recreation paths, quote unquote, and that they are at the border of surrounding properties, and they turn into recreation paths for motorized bikes, ATVs in particular. And now there's also motorized bicycles, believe it or not. And I know that's not what the intent is, but there's nothing wrong with making it clear that these are natural recreation paths not to be used for motorized bikes. That does not deprive the developer of a realistic development opportunity under fair share housing, certainly. Number two, with regard to this requirement of allowing the recreation path within the 50-foot buffer, the proposed change is merely that notwithstanding the developer's desire to put a recreation path within the 50-foot buffer, it says in the original language, provided that adequate landscaping is provided to satisfy the intent of the buffering to all existing property lines. I don't know what that means. As a developer's attorney, objector's attorney, a board chairman, I don't know what that means. And that is dangerous. What I'm putting in here as a proposed change is to make clear that notwithstanding what the developer does with regard to recreation paths within that 50-foot buffer, that the 25-foot landscape buffer that's set forth in subsection 9 below is met. And there is nothing that prevents the developer from doing that. And at the same time, if he did not do, if he complied with what I'm proposing, he would still have a realistic development opportunity. He would have what Mr. Phillips is talking about in terms of 165 total units with 33 affordable units in the layout that developer proposes. Not one iota of a change to that plan. That's number two. Under D4, there is a comment about the 300 feet from the TH8 zone for recreation, social, communal facilities, but there's no reference to, if you look at D4, the outdoor recreation facilities, and that's an inconsistency in your ordinance that is not complied with. And so for purposes of clear drafting, certainly that addition should be made to make it clear what the 300-foot requirement applies to. And I also, for wordsmithing, I made it clear at the end that the setback requirement shall not apply to natural recreation paths, because I felt that the preamble, except for recreation paths, doesn't make any sense and it's open to interpretation. I also have a comment here as to there's no reason why recreation paths cannot be placed outside the 50-foot track boundary, such as on the other side of, let's say, a detention basin, and still meet the requirements of the plan and still allow the amount of development, the amount of recreation paths, the amount of driveways and pathways as are intended by the developer.
Council, can I ask you a question?
Yeah, of course.
With respect to D4,
For D4, yeah, sure, go ahead.
do you, and this is not me trying to
I
set you
understand.
up, do you not think that your language adding outdoor recreation facilities is redundant? Recreation facilities is already included in the first sentence.
Well, I'm going to go right back to you.
Yeah, no.
If you look at B3 and 4, there is some redundancy. Yeah, if you go up to B3 and 4, there is redundancy there. Because B3 says recreation, social, communal facilities, and B4 says active and passive outdoor recreation facilities. The point I'm making, Mr. Nunn, with that is, look, I don't want to waste my client's time and money with wordsmithing, but here, because there's not a clear connection between what the intent is there regarding the 300-foot buffer and what the language is in B3 and 4, what I try to do is just try to parrot it so that there be no ambiguity whatsoever. So I'm taking B3 and 4 and I'm moving those requirements down to D4 so it's clear that that's what is intended, because I believe that it is what it was
So
intended.
now I have a question for Mr. Phillips. D4, active and passive outdoor recreation facilities. And I understand from a litigation perspective why you're raising the issue. Is there a reason that in D4, active and passive outdoor recreation facilities are used? However, in D4, we just use sort of a broader phrase, recreation. There's a comma, but it's applying to facilities, it modifies facilities.
There's no particular reason, but I actually agree with you. It's very clear to me that it says no recreation, which implies indoor or outdoor. I don't see the need to add the outdoor language. I think it's perfectly clear.
So guess what, again, just not saying one way or the other, but I think what council's saying is, but you then have in B4, active and passive outdoor recreation facilities. Could one looking at this say, well, wait a second, there must be some outdoor recreation facility that could be allowed in D4 because you've specifically referenced
I don't
outdoor.
look at it that way at all. I think it's perfectly clear. Notwithstanding the different language. It
No, I
says-
mean, I agree that the grammar, the way D4 is written, recreation facilities,
It's clear, whether indoor or
It's
outdoor, it's clear.
anything.
And I don't think it needs to be weighed against D4, the fact that outdoor is specifically mentioned in D4. I don't think that in all way trumps or changes what is meant by D4. I think we're fine. That's my opinion.
Okay, Mr. Dunn?
If I can.
Yeah, thank you. I just-
I'm sorry.
Ms. Snyder, go ahead.
Yeah, thank you. You know, and I made the comment about, you know, why the paths need to be within that 50-foot buffer. So I will just move on. If you look at now D5A4, I just make a comment here with regard to it, and I appreciate the concern about the height issue, and that there would be provision in terms of that within the 100 feet, you know, there would be no point, I guess, that's higher than 35 feet. The problem, and I mentioned this earlier actually, the last time the ordinance was adopted, is that we have to be very, very careful in terms of what we're talking about by definition. Because here, we're talking about the definition of finished grade. So the concern always is that a developer will import soil or move some soil around and put a building or buildings on mounds. And if you put a building or buildings on mounds, and you look at the ordinance, you look at this ordinance, and you look at the definition section of the township ordinance, and you measure from finished grade, you're not measuring from where the land is today and going up 35 feet. You're measuring from the top of that mound, wherever that top of the mound ends up, and then going up 35 feet. So while I understand and I appreciate on behalf of Liberty Greens the effort to be concerned about excessive height for these buildings, I'm just making a comment here for the Township Committee's consideration that, in fact, that based on the way the ordinance is written and the applicable definitions, that you could end up with a very, very tall building that is much taller than the buildings in Liberty Green, not to mention the fact that the Liberty Green requirements are 30 feet. I mean, they're even shorter. So that's just something that I ask that the Township Committee consider. Under B2 on that same page, I make a point about not only should the building containing dwelling units be located not less than 50 feet from any tract boundary line, but we also make a request that any associated accessory structures also not be located. It's one within the 50-foot tract boundary line. It's one thing, and I made this point before as well, it's one thing to allow recreation paths within that 50-foot buffer if they're absolutely needed for pedestrian walking, what have you, as long as, of course, you maintain the 25-foot landscape buffer. It's certainly another thing to put other structures, whether it's temporary or permanent, whether it's swing sets, whether it's sheds, whatever it is, whether it's dumpsters within that 50-foot buffer, because, again, we wanted something much more than a 50-foot buffer to those buildings. And we agreed that for the betterment of all, in terms of the project, so that the project could work on this constrained site, we agreed to the 50-foot buffer, but what's happening now is that the 50-foot buffer is essentially becoming, no pun intended, eroded. And so we're trying to avoid that, and it's like, be careful what you agree to in concessions, because then we're agreeing, yes, we'll accept the 50 feet and not something like 100 feet, but now the 50 feet is even being scaled back. So we certainly ask you to reconsider that. And again, on the next page, again, for refuse areas, whether it's dumpsters, should also not be located within 50 feet of the TH8 zone. And then finally, with regard to number 9, on that same page, we added that the development shall provide for and maintain. Not only is that better wordsmithing, but to make it clear that the maintenance obligation should be on the development at all times, not just for the installation. And that the screen should be a dense screen, and that the preference certainly would be to utilize existing vegetation and not small white pines that are staggered on a double row that you can see right through with their branches falling off every year, and is not going to be an effective buffer. So the concern here, and I will tell you as a land use practitioner, that if you decided to make every single one of the changes that I proposed, you could A, do them tonight, B, it would not require a reintroduction of this ordinance, C, it would not change the development that has been proposed to you by the sisters one iota in terms of density, circulation, landscaping, buffering, other than to adhere to what was originally intended by virtue of discussions by all parties involved, and that there is no way that if you adopted every one, let alone any of these proposed changes, that the developer would be deprived of a realistic development opportunity for affordable housing. I will also add and just remind you that under the settlement agreement originally with fair share housing, that it actually states in relevant part, let me just get to it, that no developer, this is in the fair share settlement agreement that you signed, no developer has any right to rezoning, and that the township's unmet affordable housing need shall not be deemed a legal reason to give any developer the right to rezone. Well, you did give the developer the right to rezoning, but at least let's do it in an intelligent fashion that doesn't hurt the developer, doesn't hurt Liberty Green, doesn't hurt the surrounding community, and is consistent with not only the master plan, the amended fair share housing element, but also with your existing ordinance, so that when you go ultimately before the planning board, or this developer goes before the planning board, the rules are clear and you don't end up with a project that you don't intend and that is adverse to the surrounding community, so that everybody wins. And that's why we're here. We're not asking that the project get blown up, that you start over from scratch. These are little tweaks, admittedly, but they are important tweaks. Otherwise, my client would not pay me to come here. That being said, we appreciate you listening to us, not only tonight, but also in the past, and we hope that you give it sincere, serious consideration.
Thank you very much, Mr. Simon, for your comments. Anyone else in the public care to be heard? Peter.
My name is Peter Broman. I live at 79 Independence Way. That is block 8701, lot 43, which abuts lot 8801, lot 1. And I'm appearing, well, I'm an attorney, I'm not a land use attorney. I'm appearing as a homeowner whose property is affected, seriously affected. But I have a couple of questions. I was a little bit distressed to listen to the last presentation, and I want to make sure that the ordinance that I am looking at, which is the one that was sent to me by certified mail, is what you're considering, not some amended ordinance. Were there amendments? I guess this is a question for Mr. Mills.
No amendment.
There's no amendments, these are just proposed suggestions of some
What
kind.
you're considering is exactly what you received.
And I wanted to also, first of all, thank Mr. Mills particularly for the courtesy he's shown me, because I'm not appearing as counsel, but he's treated me a little bit as though I am. And he's copied me on a number of things.
I'd
I'm
like to
very,
thank
very
you for your
grateful.
input in assisting finding a gap that we had in our draft, so I
Well,
appreciate that.
I just wanted to thank you publicly. Now, I felt that the township tried to honor the concerns that we expressed at the last hearing, and I was grateful. And then I saw the revised ordinance that was apparently negotiated over the summer with the Sisters Council, Mr. Eisendorfer, without any input from Mr. Simon at all, as far as I know. I certainly have had nothing to do with it. And I have only one comment that I'd like to make, but it's very important to me as a homeowner because it comes within, I think, about 20 feet of my property. And I felt that the easiest way to address the issue would be to prepare an exhibit of the proposed site plan, so that it'll be a lot quicker if you'll let me give you this exhibit, then I can just point to it and my presentation will be a lot shorter. And I realize there is a time limit. So is that all right if I just hand these out? And I also want to, I'll explain it in a second as I go on. I just want to represent first that although it's going to sound like it, there was absolutely no coordination between Mr. Simon and me. I'm here as a homeowner, but it turns out that what he's talking about in section 95-20.2 B parentheses 4 on the top of page 2 of the statute is what I want to address. And that is that recreational path. Now, if you look at page 1 of my exhibit, I don't know if it's marked, is it marked at all? Is it LG or 2?
No,
Yeah, you're not going to mark it? Well, let's just call it Roman exhibit then or something. Page 1 is a site plan, which I received from Joe Alesso, which I presume is what's going to happen. Page 2, this is all the site plan. Page 2, I've just zeroed in a little bit on that path, that recreational path in the lower left-hand corner. That's the dotted double line. And it comes next, as you can see, to that boulder dotted line, which is the Liberty Greens property line. And you can see in the extreme lower left-hand corner, the last building of Liberty Greens. I happen to live in the middle of it, just about where that recreational path comes closest to where that black line is. And if you look again on page 2 of the exhibit, I know it's quite small, but there's a map to scale there. And if you can read it, which I have to take my glasses off to do, the first mark on that is 30 feet. So that first black hash mark on the scale map is 30 feet, and that is considerably smaller than the distance between the so-called recreational path and the Liberty Greens property line. Now, I live there, and I've lived in a townhouse association, which I like, for 37 years. And there are problems in townhouse associations. Ours is pretty well run. But things fall apart, and people have to complain to get them fixed. Because no board wants to spend money unnecessarily. Eventually, whatever landscaping there is going to deteriorate, and there's going to be no interest on the part of this new association right next to us to maintain it, because there aren't any houses there. There's just that path. And what is that path? This is where I think Mr. Phillips, whom I appreciated, listen to me particularly, because we did have a meeting before before he entered into negotiations with Mr. Eisendorfer. And I said, we were really, at Liberty Greens, we were really concerned about the possibility that people would be climbing over our fence or somehow breaching our property to get to the railroad station. And wouldn't it be wonderful if there was an access path from this property to Convent Road, which is the road that goes into St. Elizabeth from the from the Convent train station. And on page 2 of the exhibit, you'll see it marked there at the bottom, Convent Road. So the idea, I think, is for people to be able to walk to the station every morning and every evening, come back from the station. I was educated to listening to Mr. Simon. I never thought of ATVs. That would be horrible to me, to have those essentially 20 feet from my property line. They have ATVs going. That's not the intent of the statute, I think, or the ordinance. I think it's to have a 50-foot barrier that's landscaped. So if you look again more carefully at page 3 of my exhibit, which is again just a little bit closer zeroing in, you'll see that recreational path, and you'll see a stormwater basin. Now there's nothing between the recreational path and the stormwater basin except that it is steeply sloped. I'm not an engineer, I can't describe it further, but I live there, I've looked at it, there is a slope there. But it seems to me that the only reason that this recreational path is breaching that 50-foot barrier, the 25-foot barrier in my case, is to reduce the cost to the developer, because I don't understand why he can't put the path closer to the stormwater basin, and he might have to have a retaining wall there.
Peter, this is not the Holy Grail. This is purely conceptual. None of us up here know what a proposed development on this site would look like, or where the walking paths will even be.
That was actually one of my questions from Mr. Simon at some point, but I guess I never got to it. Where do we object to this? So let me get to the language of the statute then. If we look at the same statute, or the same section that Mr. Simon was talking about, B4, to me, and I have been a lawyer for a long time, just not this time, it's very vague. It's going to cause problems. I don't want litigation between Liberty Greens and the township. I especially don't want litigation between Liberty Greens and its next door neighbor to be. That's a horrible situation to be in. But you say here, number 4, active and passive outdoor recreation facilities for the exclusive use of residents and guests. The minimum setbacks for property lines and streets shall be the same as for principal uses and structures, except as otherwise provided herein. And then you go on to otherwise provide. Recreational paths not exceeding 6 feet in width may be located within the 50-foot tract boundary setback areas, provided that adequate landscaping is provided to satisfy the intent of the landscaping buffering to all exterior property lines. Now we're in court. What is the intent? What is the intent? Why don't you just say, provided the 25-foot landscaping buffer specified in section 9520.2 D9 is maintained? Makes no sense to me. You have a vague statute here. But I'd also like to know why it can impede on the 50-foot line, which I already addressed. And Mr. Mills said, well, this isn't the place for it. But I don't understand why we even need that second section. Why can't subsection 4 just stop after the word structures? And for the reasons that Mr. Simon said, I don't think that will hurt the developer at all, except he may have to pay a little bit more for a retaining wall. But if he needs, you want to wrap me up, okay? Let me just finish. But he wants, it seems to me, and Mr. Mills can correct me, the place to address that would be in a hearing for a variance, not here. But let's make the statute a good one. The last thing I want to do, and I said I would wrap up, I just want to call your attention to what I think is a typo. I'm not even going to comment on it, but on page 1 of the ordinance, section 4, right under section 4, the word replace should be replaced with a D. You hear that, Mr. Mills? You see what I'm saying?
Yes.
Okay? So I thank you for your attention.
Thank you. Would anyone else care to be heard? Your name and address, please, ma'am.
Susan Cantor, 30 Pilgrim Court, Liberty Greens. I'm not sure that this is the place or the time, but my concern is, in addition to the other things that have been mentioned, the concern about Punchbowl Road. Traffic has already significantly increased on Punchbowl Road, partly because of developments in Fleur Park. There's a lot more traffic just in the 3 years that I've lived here, going past my house, which actually happens to back up onto Punchbowl Road. There's also been a lot more repairs having to be done all the time in the part of Punchbowl Road that is just under the railroad bridge and approaching the stop sign. There have been quite a number of repairs in the last year, which involves sometimes during the day diverting traffic around because of the repair crews. Any other developments that come along here, this development that we're talking about this evening, the other one that's going to be built in Florham Park on the sister's property, and what's already happening with the buildings at Columbia Park, are certainly increasing the traffic on the road. Not a lot to do about that, but I'm asking that the Township Committee consider what we can do about keeping that road in good repair, managing the traffic. I'm wondering what's happening with that traffic light that's at the corner of Madison Avenue that's been there now for almost 4 months, but not turned on. So the traffic during rush hour is just unbelievable. So these are my questions and the questions of a lot of my neighbors. I don't know if this is the right time, but we'd love to know what's going on with the plans for the road, with the maintenance of the road, with the traffic light, and so on.
Thank you very much for your comments and your input. We appreciate it.
Okay. Anything about the traffic light?
Well, DOT now. The New Jersey DOT that's looking like. I haven't heard anything from them as to what they're going to look to switch.
Okay, thank you.
Lee Goldberg, 10 Arrowhead Road. As a result of the collaboration that was done between the township and the Sisters of Charity and other interested parties to come up with, I don't want to call it a site plan, but with a revised plan for the development, is there any detailed map sort of that, I know Mr. Rose, you said we don't know exactly what the development's going to look like, but some sort of anything available for the public with where the units would be, or anything more detailed that can be made available?
In fact, Mr. Goldberg, what appeared in Mr. Broman's hands was never permitted to be released by the sisters. It was shown to us only as a concept tool for purposes of trying to format the wording of the ordinance, and the sisters declined permission because I specifically asked if we would be allowed to release this map to the public, and they said no, and it was their work product, so how it got in the public venue, I don't know, but it did. And the other thing is there was some complaint about the Green not being a party to the negotiations table, but as Mr. Simon knows, he was present in the court when I asked the judge about that, and Judge Neergaard entered an order, which Mr. Quinn refreshed me on, that basically denied Liberty Greens a seat at the table. So, the township has, and I don't mean to use this as a self-aggrandizement, but the township has, in my opinion, gone out of its way to attempt to accommodate, and in fact has accommodated all the concerns of Liberty Greens, and to fixate on a concept plan. There's nothing specific, and that's the purpose of site plan. When something comes in before the planning board, and the devil is always in the details, that's when the minutia of this thrashed out. How close the recreation trail is to Mr. Broman's home, how close where it meanders through. And I'll go on a little bit and editorialize. I didn't want to be perceived as flippant, but I was going to ask Mr. Broman, who I respect, has got a great intellect and a very pleasant manner, but does Liberty Greens allow motorized ATVs to run around their development? Of course not. And whatever townhome association takes over this project is going to have exactly the same prohibitions, right down to the color of everybody's front door being the same. So much of this is a big sandstorm about nothing, in my humble opinion.
Okay.
Thank you.
Thank you for that update. Yeah, again, like, when you had said, obviously nothing's set in stone, but I would imagine the way the zoning is, there are certain constraints with the landscape that's a part. We have a general sense of where the units will be. I'm not saying, show me a final plan right now, and all that, but there's some, so the answer is no, there's nothing available to the public.
That we have, correct.
Okay. And the only reason I ask, and I'm not sure about the sandstorm we referred to and all these other things, this is all news to me in terms of just learning it here this evening. The only reason I ask is because 2 meetings ago I had asked if there was going to be a map made available, and there was some overtures made at that point that yes, there would be something made available as a result of the collaboration between the Sisters of Charity, the township, and parties involved. So I was just curious to see what...
We wanted to make it public.
Okay.
They said no.
I understand. Thank you
We
for...
felt duty bound.
Okay. Thank you. I appreciate that.
Thank you.
You're welcome. And I want to also ask Mr. Phillips if he could just elaborate when you were explaining how, I guess, the TH6A 8/AH zone is going to be laid out. You had indicated there were a couple of numbers in there, 500 feet of separation. I don't know if it went down to then 400 feet. But when as you were describing the layout of this new zone, you mentioned the stacked townhomes. Are these stacked? Is this going to be the first instance of this use of deployment of these stacked types of units in Morris Township? Are there any other examples
I
of
don't
this?
think there are, right? We've got conventional townhouses, we have multifamily buildings, correct?
More estates.
More estates?
More estates.
More estate.
More estate.
And more estate,
Has
correct.
stacked townhomes.
So-
The new Colgate place.
And the new Colgate place will have the stacked. Correct. Okay. And as you were describing how the zone was laid out, Mr. Phillips, and I don't know if this ordinance speaks to how the final deployment of these different types of units, the multifamily, the market rate, and then what was the third one, the affordable housing use?
So just to summarize,
Yeah.
the multifamily affordable buildings, which we house the 33 units of affordable, they must be located at least 500 feet from the Liberty Greens common boundary line. Okay, so they basically have to be in the easterly portion of the property. The stacked townhouses can't be closer than 400 feet to that common property. So for 400 feet, the transition on the Sisters property will be all townhouses, consistent with what's on Liberty Green. We wanted it to be the smoothest transition and afford the maximum protection to Liberty Greens. And we also required that, because we had to change the height requirement for this zone to let them take advantage of some of the slopes, that any one of those townhouses that faces onto Liberty Green, the height from that face, so that facade, can't be more than 35 feet. Again, to provide the most effective transition and maximize the protection. So those are sort of the key parameters. And the last one, of course, being the recreational facilities, whether indoor or outdoor, have to be at least 300 feet from that common boundary line.
I guess, so, and thank you for clarifying that, because as you were describing and talking about smooth transition, effective transition, to me it almost sounded like you're actually going from one type of, and correct me if I'm wrong, one type of housing stock to another. You're going from...
Correct.
And the further you get away from Liberty Green's property common boundary, that's where the affordable units will be the furthest away.
Correct.
So is there something, there's just something that just seems on the surface to me as a resident of the town I live, is that the way we're zoning this, we are almost sort of, when you say smooth transition, is that smooth transition from where, a different level of socioeconomic status people live versus others? I mean,
No,
what kind of, it's nothing
It's a
to...
land use transition.
It's a land
One of
use.
the concerns that was expressed to us by Liberty Greens was that there be the smoothest transition, and they clearly wanted townhouses to back up to townhouses, okay? Which is why the 500-foot separation requirement was put into the multifamily affordable units. The other thing is they did not want recreational facilities along that common boundary line. That's the reason for the 300 feet. And we also, basically on our own, because we wanted to afford that protection of Liberty Greens, on our own, we basically negotiated for the 400-foot separation to the stacked townhouse. Even though they look like townhouses, they're denser on an individual basis because the units are stacked above. So the transition from the lowest density to the stacked town to multifamily was designed on this site to afford that protection to Liberty Greens. That was the whole point of it.
Thank you. And just, if you could help me understand, when we do zone these new areas, so for example, on the Honeywell tract, I believe the affordable, old Honeywell tract, the affordable units are interspersed throughout the development. There's no building over here, that's the affordable housing, or
They are integrated and are all sales units. Whereas here, because we needed the rental bonus credits, the affordable housing has to be rental, because we needed that to get double credit on those 33 units in order to meet our number. So they had to be rental units, so that's why they're kept off as being separate.
So an integrated approach here would just not be feasible based on the numbers that you have to derive out of it from an affordable housing plan.
That is accurate, yes.
Thank you, Mr. Goldberg.
Thank you.
Appreciate it. Anyone else from the public care to be heard? Okay, Morgan first.
Jim O'Reilly, 50 Independence Way. What does a stacked townhouse look like? If you have a townhouse that's 2 stories high, is a stacked townhouse a 4-story building? How does it work?
No. A stacked townhouse can be 3.5 stories, although the half a story cannot be habitable, based on the ordinance.
Is it designed for a slope?
I'm sorry?
Is it designed for a slope?
When you say that, I'm not quite sure what.
Well, I mean that on a slope, on a hillside, you might have a lower story that is also at the ground level, as an upper story could be at a ground level, so that a 3-story building could look from one side like a 2-story building, and then downhill it would have an entrance, a ground level entrance.
Yeah, there are provisions, it gets a little complicated in the ordinance in terms of, but the ordinance takes into account the slopes and some facades of the building, of both the stacked townhouse and the townhouse may appear larger from certain perspectives, but again, we have a requirement here that from both the Liberty Green property line and as viewed from Punchbowl Road, that the absolute height of any of the segments cannot exceed the height that's specified for either conventional townhouses, which is 35 feet, or stacked townhouses, which is 45 feet. Did I say that right, Jim?
Yeah.
That's, those distances, those heights are given from the normal ground level, right?
The height is measured based on average finished grade, and we treat it a little differently than what's in the current ordinance, because we basically differentiated by townhouse or stacked townhouse segment.
But it's basically averaged around the building on the 4 corners.
So nobody can create an artificial hill or something and then put 35 feet on top of that. Nobody can create raised ground and then base their 35 feet.
Well, I mean, they could do that, and that's an issue that Mr. Simon brought up, but the developer is not going to bring in 5 foot of fill to put a unit on top of that.
Right. Wondering. So if I understand correctly, Punchbowl Road cannot be widened because of the railroad bridge or underpass. It has to go through, right?
As an engineer, you can widen anything.
You can, so, but
Just how much you're willing to pay.
you can do it while the railroad is continuing to operate?
That obviously creates a restriction.
Yes, but then there's no plan to widen Punchbowl Road, is that true?
No, not underneath the railroad tracks.
So that creates really a constriction. And there's no way, go ahead.
I was going to say there may be acceleration lanes similar to what you have at Liberty Greens, that sort of thing, where you have a taper that allows someone to accelerate onto the roadway.
And there's no possibility of having this new community have its exit lead to the Convent Road, so that all the traffic from the new community wouldn't be dumped onto Punchbowl. Like Liberty Greens is on Punchbowl, and the new community could be on the Convent
No,
Road.
it's not structured that way.
It can't happen, right?
Road frontage is on Punchbowl.
So I'm always worried, when you get to the next stage, to the planning board, you can ask a question and then be told, oh, you should have asked that back at the adoption of the ordinance. You know, we're always faced with that. Is there any change in water flow that could affect flooding in either area, either the new community or Liberty Greens, due to this structure, due to this?
All that would be designed at the site plan stage. Obviously, drainage would go in. I mean, if anything, I think drainage going in the ground helps improve drainage conditions.
And how does this affect the, what do you call it, the water,
Table.
water, not the water,
Table.
you know, the water table and the pool areas in the new property, in the,
I mean, generally, when you install drainage, you help collect the groundwater. So if anything, I would say the groundwater has the potential to go down.
okay,
When you're putting drainage underground, it tends to collect groundwater.
okay, thank you.
Thank you, Mr. O'Reilly.
Good evening, Dan Brummage. I'm representing Morris County Golf Club as Chief Operating Officer. Just a quick question, I guess, to piggyback on Mr. O'Reilly. Just didn't want to be late on the question of setbacks. 50 feet, I believe, from Punchbowl Road. What was, as the design back when KHOV and now Vision, the setbacks were determined at, I want to say 400 feet on Columbia Turnpike, and I forget the number of feet on Park Avenue. Is there any consideration to be consistent with that ruling? And I don't know if that's for tonight or is that for the planning board, so I didn't know on that. So I just was looking for that, if there's some answers like that.
Thank you. Yes, sir.
Mr. Mayor, I just wanted to address you on
Name and address, please.
I'm sorry, Joseph Falesso, 11 North Bridge Place. I'm the president of the Liberty Greens Homeowners Association. I'm here with one of our other board members. We just wanted to address the board, not to this specific subject, but we wanted to thank you. I want to thank the committee for allowing your professionals to work with us. We also want to thank you for the amount of help that your fire chief and your police chief gave us during our recent road reconstruction, as well as Mr. Slate and Mr. Quinn. Very helpful, and I think it should go on record as part of all this that we've got a township committee that listens to its residents and works with them. In spite of some of what we heard, we're happy that you worked with us. We're not happy with what's going to go on behind us. We have a council that I think gave you some insight as to what we're not happy with, but overall, I want to thank you for allowing us to talk and giving us an opportunity, and thank you for helping us with our road construction project. It was quite a bear, and you guys really stepped up. Thank you.
Joe, thank you very much. Anyone else care to be heard from the public? I'll give you 3 more minutes, sir.
I only need three.
Pardon me?
I need less, way less than three.
What kind of attorney are you? You don't need more time.
Well, because when my client comes up right before me, yeah, you know, he takes it all. Just 2 more comments. And obviously, I don't need to echo what Mr. Lesso said. That being said, 2 points. First of all, there was a comment made, and Mr. Quinn, held it up in terms of the order from Judge Niergaard. I just want to make a comment on that so that we're completely clear. Number 1, what Judge Niergaard stated, because at the time of the hearing before Judge Niergaard, Mr. Mills made a mention of the fact that they were working with Liberty Greens, which was appropriate and fair, of course. And Judge Niergaard stated, and she put it in her order, that I'm not allowing Liberty Greens to intervene in this matter, not that we asked to intervene in this matter. It further stated in the order, which I just pulled up, that we were not to participate in the negotiations with Mr. Boland, the special master. Correct. We never asked for that.
The order did go on to say, though, and it says, however, nothing herein shall prevent the representatives of the township or the township planning board from meeting with representatives of Liberty Greens as they deem necessary or appropriate. So that was included in the order. I'm just reading verbatim from the order. So I just want the record to be clear on that. And number two is, when Judge Niergaard enters this kind of order, she's looking at this in terms of, respectfully, in terms of her fair share of litigation that is pending before her. When you have fair share litigation, unfortunately, there's two components of it. It's the litigation, and then it's the compliance with whatever comes by way of settlement via ordinance introductions. That doesn't obviate the need to comply with ordinance requirements in terms of introducing and passing them, and meeting challenges in terms of if the ordinance is arbitrary, capricious, or unreasonable for any number of reasons. So I just want to make that clear, just so, because I know that Tim raised that, and I just wanted to check it because I didn't want to misstate anything, certainly before this township committee. Number two.
Well, this would be number 3.
No, that was a big number 1. Okay, it goes to 109.
This would be 2A.
John, this is 1B. So the second point I want to make is this. John made a comment, flippant or otherwise, that, I think this is just, nothing more than a sandstorm. I respectfully disagree. When you're dealing with a buffer, you guys pass ordinances, and ladies and gentlemen, pass ordinances all the time that have buffers that are, and setbacks that are much greater than 50 feet. Okay? We're here, and we do appreciate all the good work that you've done regarding this ordinance, regarding the fair share housing litigation. Don't get me wrong, but we're just talking about 50 feet, which is, respectfully, in the land use world, a big nothing. But we're real protective of that 50 feet. And when we start to erode that with paths and changes regarding the 25-foot landscape buffer, which is also, frankly, a big nothing in the land use world, we're real protective of it. And that's why we're asking and literally pleading that you reconsider just to change those little parts of the ordinance so that we can have the faith that that buffer and that 50-foot setback will not be, like I said earlier, eroded and end up as if it doesn't even exist and have no meaningful impact. And that's frankly why we're here. And we appreciate you guys listening. Thank you.
Thank you, sir.
Peter Plummer again. I have 2 more comments. I sat down because Mr. Mancuso really wanted me to, and I did. But Mr. Phillips stated in his presentation to this board that this ordinance, this is a direct quote, will continue to maintain the minimum 25-foot landscape barrier, buffer, 25-foot landscape barrier. That's not right. And I wanted to say that before, and I forgot because I obeyed Mr. Mancuso. Look please at page 3 of my exhibit again. Page 3 of my exhibit, the lower left-hand corner. You can see the Liberty Greens building. You can see the heavy black fence, property line. And then there's in very, very faint outline, there's dotted lines. That is an existing road, a dirt road that the convent uses to dispose of its rubbish back there. And I live very, very close to that. I can, whenever there's a truck passing, or anybody passing, I could literally hit them with a slow-pitched, underhanded softball. And I'm not exaggerating. It's not that far. It's very, very close. And you can see that this so-called recreational pathway actually impinges on that.
Can I address that, Peter?
Well, yes, but can I just finish my statement? Because I think it's going to... Now, Mr. Mills told me that this was not the right place for this. This is only a site plan. And that's what I want to hear from somebody. I don't know where to address this, but
I'm going to make you feel comfortable. It doesn't matter what this shows. It doesn't matter what's out there. It doesn't matter whether the concept shows the walking trail breaching the 25-foot landscape buffer. The ordinance is the ordinance. The ordinance says there's going to be a 25-foot landscape buffer. They have to do a 25-foot landscape buffer.
But it doesn't say that. That's
Sure
right.
it does.
No, it doesn't. And that was in my original presentation.
How does it not say that? Let's look at what it says.
That is what I tried to say in the first place. Sorry. That is what I tried to say in the first place when I said that it was vague. I said, quoting the second sentence of B, paren 4, close paren.
Forget that. You go to number 9.
I can't forget it because it says, provided that adequate landscaping is provided to satisfy the
Go
intent.
to number
Listen to the expert, please, Peter, he has the right.
on the second to last page at the bottom, number 9. C9. And just read it.
I did. Development shall maintain a minimum 25-foot landscape buffer to all exterior property lines to provide an effective year-round screen, etc. Except that B4 says recreational path, or excuse me, the first sentence of B4 says minimum setbacks from property lines and streets shall be the same as for principal uses, buildings and structures, except as provided herein, and then it provides differently in the sentence that I struck.
You're conflating setbacks with buffers.
Well, that's possible because this isn't my area.
Okay, so there's a setback requirement to the dwelling, which in this case along the property line, townhouse to townhouse, 50 feet, just like your townhouses are within 50 feet of the common property line. What this is saying is, notwithstanding what is either shown on a concept plan, a rough concept, or even if there's a dirt trail out there today, they have to provide a 25-foot buffer. It's in the ordinance. The only way they can get around it is ask for variance. It's in the ordinance.
That's, okay, thank you. And I just want to say again though to Mr. Mills, and I said in my presentation, I had no idea of the concept of an ATV until Mr. Simon mentioned it. It's just, groups of people walking back and forth from the train station, really 25 feet, I guess, from my deck every morning that I don't want to see.
I wouldn't lose any sleep over that if I were you.
Well, no, because we have the same issue. Absolutely, we have exactly the same issue. We have a pathway to Convent train station, and I've walked on it for 25 years, and I've always wondered about the people who see us every morning passing so close to their houses.
Peter, thank you so much. Anyone else care to be heard before I close the public hearing? Yes, ma'am.
Diane Holland, 26 Northbridge Place. I appreciate all of the efforts put into this, but I want to know what our remedy is if the developer chooses not to follow the ordinance, or after a period of time lets landscaping go to seed, or does run ATVs behind Mr. Broman's unit. What is our remedy?
And that's why you have your
Ms. Hall,
planning board, you have your experts, you have your planner, you have your attorneys, and the ordinance, you have the ordinance, the ordinance has to be followed.
To act contrary to the ordinance is a violation of the ordinance, and it's addressable in either municipal court or by way of civil action to compel compliance.
Okay.
Thank you, ma'am. Okay, finally, anyone else care to be heard from the public? If not, I will close the public hearing. And then I will ask the township committee if they have any comments.
Yes, I have several questions and comments. From my point of view, the ordinance that we're voting on tonight was introduced on August 15th. And I don't understand why we're getting this information today when the ordinance, the language of the ordinance has been out there for so long. This was a big objection of mine for what happened in May, because there was not sufficient time for anyone to read it or respond to it. And the information was made available on August 15th. That's when it was first introduced. I myself I've really appreciated the amount of time, and I've taken advantage of it. I've walked the site several times. I've read and reread the ordinance. I've read the proposed language of this and compared it with the original. I've reached out to people I know and asked if they had any questions or comments. And the things that I'm hearing tonight, I have not heard before, and I do have a question about, I'd like to ask Mr. Simon.
Sure.
Can you comment on why, I mean, I didn't see your letter until I walked in here at 5:45.
Yeah, well, thank you, Ms. Wilson, for raising that. I have two responses.
Yes.
Number one is that, as certainly Mr. Mills and other professionals, Mr. Phillips knows, that I participated, I was away on vacation with my family, came back the next day and participated, I think it was the next day or the day after, and participated in a telephone conference with attorneys and Mr. Phillips to go over, it was the night, it was the day of, what was it, if August 15th was the day of the introduction for that night, it was that afternoon, probably 2 o'clock, we participated, and my guess is about an hour conference call, John, give or take, right? Where I went through, based on the ordinance that was going to be introduced that evening, my concerns, including what you heard from me this evening by way of going through them, and the markup. So the answer, we finished the call, they said they would get back to me, but I did very clearly, before the ordinance was introduced, once I, right after I got a copy of it, raised our objections to the ordinance. And again, keep in mind that the purpose of a public hearing is exactly what we're doing tonight, which is, not to, it'd be great to work things out in advance if you can, but the reason why the New Jersey statutes allow public hearings on ordinances is to allow the public to voice their objection or concern. And the point is not to necessarily blow up or get the ordinance necessarily denied or not adopted, but what we're trying to actually do is make the ordinance better so it can be adopted in a manner that has clear language. And again, these suggestions were made, many weeks ago for consideration, and this is not respectfully, and I do appreciate, I know that everyone here does very, very good work, and are very genuine in their concerns about the community, but nothing we're proposing here is a heavy lift, respectfully, at all. And it's not like we're asking to rewrite paragraphs or anything like that. We're not changing numbers, right? In terms of, we don't, do we want a 50-foot buffer? No, we don't. We'd like a 100-foot buffer, but we're not touching any of that substantively. But we do think that our proposed revisions that we did raise on a very, very timely basis, and Mr. Mills knows, and I know that it's very hard when you do a fair share. We have an order from Judge Niergaard, but the reality is that the professionals here know that I was constantly in touch, certainly via email, asking, to be part of the discussion. I understand the way things work, and I'm okay with that. I'm a big boy. But that being said, we did try to, make clear as early as possible our concerns with these. This by no means was a last minute, we're going to hide things and not do anything. Never heard anything. And even today, I talked to Mr. Mills. He asked me, will you share with me? Got the approval from the client, and of course we did. This is not trying to play one-upsmanship or hide in the ball. This is trying to get a better ordinance. And we respectfully think that, again, without repeating myself, these small changes are important to not just Liberty Green, but as someone who goes through the planning board wars on a regular basis, either objecting, sitting as counsel, or even presenting applications, the ordinance controls. It's really important, and that's why we're here. Thank you. I hope that helps.
So just to be clear, you did suggest the changes that you're suggesting tonight back on August 15th,
Yes.
correct?
Yes, verbally, via the conference call. That's correct.
I knew nothing about that,
Yeah.
just for the record. I will say that
Do you have any other questions for me, Ms. Wilson?
I may come to some.
Okay, I'll stay here.
Okay. I have several thoughts that have occurred to me this evening. One is that if you step back from what we're doing here, the ordinance that's in front of us tonight has basically taken one section of the zoning ordinance that was passed in May and has revised language, first based on negotiations between representatives of Liberty Greens with our professionals, and then those agreements were then further negotiated with the sisters. And, but in the meantime, I just want to highlight, to me this is an important point, the original ordinance that we passed in May, which was 2418, or tonight's ordinance is 2418, the original in May was 1518, I believe the number was, and that ordinance included 7 different locations in our town. And that ordinance kind of came to be known as the Liberty Greens ordinance, which is, it's really a misnomer, because in fact there are 6 other locations in our town where the residents who live nearby those locations have had no opportunity to have their input incorporated into new language. And that was a big part of my concern in May, and it remains a concern. It's done, but I felt like in the interest of, the full picture, I think that's part of it. So, those people did not have the opportunity to have input into setbacks or height or any of the details that we're talking about this evening. I will say that just my initial reaction.
I would just ask one thing, Mr. Simon, you've had your time here, and I think anything should be directed to our experts.
Okay,
Any
all
questions
right.
you have, I think you're done, sir, for now. Go ahead.
Well, I heard Mr. Sisser disagree with me, but in fact, it was rushed, and the people
I think we've heard those objections from you before. And
Yes.
in addition, those folks did have the time to speak when we did the initial ordinance, correct? I mean,
They
we're
had
here,
the time,
right?
but they did not go to
They had
the
time. You just
extraordinary
said,
means.
no, you just said they did not have an opportunity to speak. That's what you said.
Okay, I stand
Okay.
corrected then.
Yeah.
That's not what I meant.
All right.
I
let's
meant that they did not go to the extraordinary means
Understood.
that we've
Let's move on,
seen
please.
by Liberty Greens.
If I may, Ms. Wilson, Mr. Simon is correct. We did engage in a conference call following the introduction of the ordinance, and upon reflection by the township professionals, myself, Mr. Slate, Mr. Phillips, Mr. Warner, and others, we determined that since we had such a delicate balance with the sisters, and that property being a linchpin of the order of final compliance with our fair housing plan, and given the, and I'm sorry to run on, and given the consequences of a non-acceptance or non-finding of final compliance, we determined that on balance, what you've heard tonight from Mr. Simon, although well-reasoned, was not of significant impact to the overall goodness that we accomplished for the benefit of Liberty Green, which we had heard through back channels was satisfactory to the Liberty Green homeowners. So it was not presented to you by us, maybe my mistake. In any event, so you are seeing some of this new, but at a professional level, it was determined that it didn't need to be put on your plate.
Okay, thank you. I appreciate the concerns that have been brought up tonight, and it does seem to me that those can be addressed at an association level by the rules that various, that the Liberty Greens creates, or that, whatever the town home association. Yes, that to me is reasonable. I did go to both court hearings. I'm aware of the realities of the importance of passing our settlement. I'm not inclined to jeopardize it, especially when the concerns that have been brought up can be addressed in the future at the site plan level and at the association level. But it is important to me the way communication is handled with the public, and I feel that the communication this time around, there were big improvements. I was happy to see that the notification letters went out 3 weeks in advance instead of 10 days in advance, and that everyone in Liberty Greens was notified, not just the people that live within 200 feet. And that on the Friday before this meeting, an agenda was sent out along with the text of the ordinance. These are improvements in communication that I'm really happy to see. And the one thing that I will put on the record here that is important to me is the information that we share with the public in the future about affordable housing. There's a lot of issues about affordable housing that people need to understand. And in my opinion, it's part of our responsibility as members of this governing body and together with our professionals to provide the public with the information it needs to understand what's going on with affordable housing, not just in our town, but in the state of New Jersey. And it does bring us, there are a lot of concerns here. I fully support affordable housing. I'm in favor of meeting our obligation and providing affordable housing. But I'm also in favor of, sanity in traffic. And I worry about the, what's going to happen to our roads. And I do see in the future, I could see actions being taken by towns perhaps getting together to express their concerns. It's a complicated issue, but getting back to my main thing, I think we should do what we can to educate the public about affordable housing issues in our town. I've been advocating this since January. I've been advocating that we do a presentation, that we have some kind of cliff notes, I called it, and common questions and answers, and I would still like to see us do that. So I put a plug in for that here.
Thank you.
Thank you.
Mr. Sisson? Mr. Nunn?
No comments.
Just, I think we're at the crossroads here. We'll have to vote in a couple of moments. This is very, very important to us. It's very important to the township. It's important to the people who live here. And I think that the direction we're taking is the right direction. And what I will now ask for is someone to...
Well, gratuitously, Mayor, I would like to say that I think that at the request of this body, certainly Mr. Slade and Mr. Phillips and the others involved went the extra mile to try and accommodate, and rightly so, the other citizens of this municipality at Liberty Greens and balance those concerns with our need, as Ms. Wilson suggested, to satisfy our affordable housing obligation. And Ordinance 24-18, in my humble opinion, is the product that accomplishes that.
I mean, I think our attorney, our planner, Mr. Slate, yourself, John, Mr. Quinn, everybody has worked extraordinarily hard on this. And this is a critical thing for the township to promulgate and get done at this juncture. So at this moment...
Thanks to you and Ms. Wilson for going to court with us.
Yeah, thank you. I would ask for someone to offer ordinance number 57? 24-18.
So moved.
Second?
Second.
Second? Okay, roll call, please.
Mrs. Wilson?
Yes.
Mr. Sisler?
No.
Mr. Nunn?
Again, reluctantly, yes.
Mayor Mecca?
Yes.
The ordinance is carried.
All right. And Peter Mancuso, Mayor, declared the ordinance adopted and finally passed, approved the same, and directed the clerk to publish a proper notice thereof in the newspaper and to record the ordinance in the proper place. Would anyone like a motion to adjourn, please?
So moved.
Second.